Exemption from taxation. The existing statutes are divided into 15 classes, as follows. First, the property of the United States. Second, the property of the Commonwealth, except real estate of which the Commonwealth is in possession under a mortgage for condition broken. Third, the personal property of literary, benevolent, charitable, and scientific institutions incorporated within this Commonwealth, and the real estate belonging to such institutions, occupied by them or their officers for the purposes for which they were incorporated. Fourth, all property belonging to common school districts the income of which is appropriated to the purposes of education. Fifth, the Bunker Hill Monument. Sixth, the household furniture of every person, not exceeding $1,000 in value, his wearing apparel, farming utensils, and mechanics tools necessary to carrying on his business. Seventh, houses of religious worship, and the pews and furniture, except for parochial purposes, but portions of such houses appropriated for purposes other than religious worship shall be taxed at the value thereof to the owners of the houses. Eighth, cemeteries, tombs, and rites of burial, so long as the same shall be dedicated for the burial of the dead. Ninth, the estate, both real and personal, of incorporated agricultural societies. Tenth, the property to the amount of $500 of a widow or unmarried female, and of any female minor whose father is deceased, if her whole estate, real and personal, not otherwise exempted from taxation, does not exceed in value the sum of $1,000. 11th, mules, horses, and neat cattle less than 1 year old, and swine and sheep less than 6 months old. 12th, the poles and any portion of the estates of persons who, by reason of age, infirmity, and poverty, are, in the judgment of the assessors, unable to contribute fully towards the public charges. 13th, beet sugar manufactories, for 10 years from 1872. 14th, so much of the income from a profession, trade, or employment as exceeds the sum of $2,000. 15th, railroad bed, including a strip of land 5 rods wide, and the fixed property upon it. 1. No state has the right or power to tax United States property. 2. The state would gain nothing by taxing itself. 3. The exemption of this class of property is altogether too sweeping in its application. A truly charitable or benevolent institution may justly claim the right of exemption if placed under the supervision of the state's Board of Charities or the tax commissioner. The people have a right to know upon what grounds an exemption is allowed as well as that of an appropriation. They are equivalents in principle, consequently require the same supervision. When there is no question as to the right or justice of an exemption, the simplest and most convenient way to effect an appropriation would be to exempt. This would save time and expense. Some political economists claim that there should be no exemption, that all property should be assessed, and if the object claiming an exemption proved to be such as could rightly claim the support of government, that an appropriation be made therefor. This would bring before the people the subject of exemption in all its various forms, and likely would have the effect to discontinue most of them for the want of a just and equitable right in claiming government support. We cannot too urgently impress upon the people the clearly expressed and guaranteed rights of each individual citizen by the Constitution of the state, based upon the principle of the equality and natural rights of all men. Therefore, when the existing laws fail in protecting these rights, they fail in fulfilling the requirements of the Constitution. Each citizen can claim an equitable and just taxation, and this gives him a tax right in all taxable property throughout the state, and we may say an inalienable right in such taxable property so long as it remains within the state. No privileges or immunities are asked for by the taxpayer other than that of equal rights in all taxable property. But does not this tax right estop the general court the right to grant these privileges and immunities unless such grants carry with them the conviction to the people that they are in accord with their rights and the obligations of the state? Literary and scientific institutions may rightly claim a certain amount of benefits dispersed to the people, and for these benefits they can justly claim an exemption from local taxation upon such real estate and personal property located upon their grounds and used for the especial purposes of the institution, and from which they derive no further income. But when government exempts all the property which may be donated these institutions from time to time, thus making them general receptacles for exempting taxable property, she exceeds her prerogative, and despoils the citizen of his just rights, by not taking into consideration the individual welfare of the citizen, or his tax right in all taxable property. In the appendix to the Commissioner's Report of 1874, we find the amount of property exempted throughout the state belonging to the several institutions enumerated in the 3rd and 9th classes of exemptions to be $23,702,300, and this we find very unevenly distributed throughout the state. Middlesex County having $9,401, 100, Suffolk, $7, 111,600, these two aggregating about 2/3 of the whole amount. There can be no objection as to the amount of property these institutions may hold at present, provided it is not removed out of the right of taxation, and thereby wronging the people out of their taxable right in such property. For an illustration, we will mention some facts in regard to Harvard University. The property owned by this institution situated in Boston is now taxed. The title to this property consists in registered deeds. The securities held by this institution, establishing their titles in other property, are papers considered quite as valuable as an investment as the deeds securing real estate in Boston, or they would not have been purchased. Then, upon what principle does government assess one and exempt the other? Certainly not upon any just principle. Some of the securities held by this institution no doubt are taxed through the right of a franchise tax, but the failure to tax them all shows the great need of a proper, just, and efficient system of taxation, as well as the injustice perpetrated upon the people by exempting the property of institutions far better able to bear the burden of taxation than those who are now taxed to support them. In the President's Report of Harvard University, 1877, we find the following statistics: income $556, $767.43, payments $497,433.83, net gain $59,333.60, donations within the year $212,483.07, increase of capital, $271,816.67, number of students, 813. These paid into the general fund, $158, 406.90, leaving a deficit in the expense account, to be provided for from other sources, of $339,036.93. This deficit was taken from the income of the several donated funds belonging to the institution. Add to the income a fair interest upon their real estate in Cambridge, valued at $3 millions and a quarter, and divide this sum by the number of students, and we have an approximate idea of what it costs to acquire a collegiate education in Harvard University. We mention these facts as going to prove that the benefits are local, and are not such as would warrant an appropriation of the public funds for the support of this institution, or that of any other under like circumstances, and if we cannot justly appropriate we cannot exempt. There should be no question as to the propriety of an exemption in the minds of the people, and such a one is readily found in the 4th class of exemptions. No one ever questions the propriety of exempting this class of property, and every citizen is ready and willing to be taxed for the support of our common schools. The benefits are at once apparent, and equitably distributed. The question of benefits derived from the common schools, as compared with those of the higher educational institutions, may well be compared to the benefits derived from the producing and non-producing citizen, both essential to the community. We must have the producer, but can do without the non-producer. 5. Bunker Hill Monument. This we pass with uncovered heads, reverently honoring our ancestors, who fought against unjust taxation. 6. The law exempting this amount of household furniture is just. We believe those houses wherein there should be a large excess over this amount, should be examined by the assessors when there rests a belief that a correct return had not been made. 7. Mr. Francis E. Abbott, in his communication to the Commissioners, divides his remarks into parts. The 5th of these we take the liberty to insert. 5. If exemption from taxation, therefore, is granted to any species of property, it should be such property alone as might, with equal justice, receive a direct appropriation. I would lay the greatest possible emphasis upon this principle. Exemption from taxation is a violation of public faith in all cases where a direct appropriation would not be equally proper and just. Does it need any argument to prove that exemption and appropriation have the same effect? When the same disposition of public funds takes place from either act, would it make any difference to a landlord whether he exempted a tenant from the payment of a month's rent, or whether the tenant should pay the landlord the money, and the landlord should hand it back to him as an appropriation for his benefit? Admit that the landlord and tenant represent the church and state correctly, and it must be admitted that exemption and appropriation are equivalents. Government, then, in exempting church property, indirectly appropriates the public funds to the support of the church, while the act is clearly unconstitutional. Article 3 of the Bill of Rights, which was the law up to 1833, has the following clause: the legislature shall, from time to time, authorize and require the several towns, parishes, precincts, and other bodies politic, or religious societies, to make suitable provision at their own expense, for the institution of the public worship of God, and for the support and maintenance of public Protestant teachers of piety, religion, and morality, in all cases where such provision shall not be made voluntarily. In 1833 the above law was repealed, and Article 11, which is the law now in force, was substituted, the material portion of which reads as follows: and all persons belonging to any religious society shall be taken and held to be members until they shall file with the clerk of said society a written notice declaring the dissolution of their membership, and thenceforth shall not be liable for any grant or contract which may be thereafter made or entered into by such society, and all religious sects and denominations, demeaning themselves peaceably and as good citizens of the Commonwealth, shall be equally under the protection of the law, and no subordination of one sect or denomination to another shall ever be established by law. In the law repealed, religious institutions were to be supported by forced contributions unless voluntarily supported. And in the law substituted, each member of a society can, at any time, effect a dissolution of his membership with the society, and, thenceforth, is no further liable for its support, or any contracts which such society may enter into. The law, as it now stands, allows of the greatest freedom in all forms of worship, and declares that no subordination of one sect to that of another shall be established by law, and immediately thereafter subjects all taxpayers to a yearly tax in support of churches. At the same time, this tax payer may be declared by the churches to be a heretic, atheist, or in want of any other religious principle, while the taxpayer may claim to be a deist, and to respect the rights of his neighbor at least. Churches are equally severe upon each other, and, as a matter of conscience, would it not be better for each to support its own? The law also declares that the members of a society only shall be liable to its support, yet, through the exemption of church property, it requires all to support the church. These inconsistencies in the law should be made consistent, either by establishing the constitutional right to exempt, or repeal the statute exempting church property. Churches bear the same relations to each other that individuals do in regard to worldly goods. There are poor and wealthy churches as well as poor and wealthy individuals. Trinity Church of Boston cost $650,000. Trinity Church of New York City holds property to the amount of $15 million. What amount of property these churches might absorb in time, would perhaps seriously affect taxable property, and their influence might be such as not to add to the welfare of government. We, as a Protestant people, have established the right of every person to worship God according to the dictates of their own conscience, allowing the greatest freedom to all, so long as they do not disturb or interfere with the rights of others. This is all that any church or member of society can reasonably ask of government. Then let us guard well the rights of the state and grant no immunities, but establish in addition to the rights already established in religious matters, that of conscience, repeal the law of exemption, and allow of no infringements of the church upon the rights of the state. Chapter 2 of the Collection of Taxes. We give below sections 4, 13, 14, 15, and 16 of the law relating to the collection of taxes in Massachusetts. They are too disgraceful in their nature to have been enacted in a civilized state, and we are safe in saying no Christian then in the legislature voted for them. Section 4. When the credit of a person taxed is considered doubtful by the assessors, they may, by a special warrant, order the collector forthwith to compel payment by distress or imprisonment, whether the tax is made payable immediately, at a future day, by installments or otherwise. Section 13. If a person refuses or neglects for 14 days after demand to pay his tax, and the collector cannot find sufficient goods upon which it may be levied, he may take the body of such person and commit him to prison, there to remain until he pays the tax and charges of commitment and imprisonment, or is discharged by order of law. Section 14. When the collector commits a person to prison, he shall give the keeper thereof an attested copy of the warrant, with a certificate thereon, under the hand of the collector, setting forth the sum which such person is to pay as his tax, with the cost of taking and committing him, and that upon his having neglected payment for 14 days, or otherwise, as the case may be, and for want of goods whereof to make distress, he has taken his body. Section 15. When a person committed to prison for non-payment of taxes, desires to take the oath for relief of poor debtors, he may represent the same to the jailer, and the jailer shall make the same known to some magistrate named in Section 1, Chapter 124 of the General Statutes, and the magistrate shall thereupon appoint a time and place for the examination of the debtor, and shall direct the jailer to cause the debtor to be present at the same. The notice required in such case to be given to the creditor, may be given to either of the assessors or the collector by whom the party was committed. And the assessors and collector, or any of them, may appear and do all things which a creditor might do in case of arrest on execution. And if the person so committed to prison for the non-payment of taxes is unable to pay the same, he shall be entitled to his discharge in like manner as persons committed on execution. Section 16. If such person is discharged, the collector shall be liable to pay the tax, with the charges of imprisonment, unless he arrested and committed the party within 1 year after the tax was committed to him to collect, or unless he is exonerated therefrom by the city, town or parish to which the tax is due. We have condensed this subject matter as much as possible, stating the facts as they appear to us, with as few comments as would serve to make it easily understood, and endeavoring at all times to present the subject impartially, with but one object in view: equitable taxation. To our brother debtors we would say, we have undertaken to present this system of equitable taxation to the people for their consideration, based as it is upon your rights, which have been so long ignored, that were the amounts of money paid back to you which you have paid for unjust taxation, it would come near bankrupting the state. For this we ask your support. Read the pamphlet, study its principles, and ask your neighbor to do the same, and through this means, and what may follow, we may be able to establish equitable taxation. We are indebted mainly for our information upon taxation to the Commissioner's Report of 1875. Also valuable papers in the appendix of this work from Charles W. Eliot, President of Harvard College, Francis E. Abbott, President Boston Liberal League, William Endicott, Jr., The Taxation of Tangible Things Only, Professor A. L. Berry, Williams College, Taxation, Albert Boca, C. J. Holmes, James Adams, L. Maltby, and A. H. Evans, Committee of Associate Savings Banks, Alonson W. Beard, Income Tax, Repeal of, George S. Pendergast, Income Tax, Against Repeal, A. Z. Brown, Income Tax, Against Repeal, B. F. Stevens, Life Insurance, William Minott, Al Jr., Taxation in Massachusetts, pamphlet of 73 pages, showing the inconsistencies and injustice of the present law, and advocating exemption of credits.